So I'm going to address that question in a form like a scorecard. So, but before we go there, the first thing is that there is no perfect law. And you know that running statement that says that innovation is always ahead. So regulation always trails innovation. So no matter how futuristic, because again, it's a question of balance. If you try to be too exact in your regulation, you might frustrate innovation. And if you also try to be too broad, there might be nothing particular that people can hold on to. So the NDPA is not on its own in that respect. However, in terms of the NDPA and the protection of like emerging technology, I think that the law has done fairly well. As a matter of fact, one of the things I really like about the NDPC and what they are doing is the guide. I think that there were major movements forward that, again, if you've been tracking the Nigerian privacy landscape from the days of NITDA to what we have now, you realize that we've come a very long way. I mean, the NDPR, you can see that we've come a very long way in terms of the granularity and the specificity and the scope of the things that we are regulating in the privacy space. So I think the NDPA is fair. It's fairly good, particularly when you read it together with the NDPA guide, which was made last year. So, for example, the guide tries to solve a particular problem with respect to household data. I think it's Article 3 or 5 of the guide goes ahead to talk about the pre-requirements that you need to bear in mind when you're processing household data. You know, for example, that even under the GDPR and almost any other privacy regulation, household data are exempt from having to comply with like privacy procedure rules and things like that. But what the guide has now said is that, see, even though it is household data, you still need to meet certain minimum thresholds, and that makes a lot of sense because today everybody is shooting content from their house. Today you can be in your house and you don't intend to sell the data, you don't intend to do anything, but somebody from like 5 houses away is using Samsung S100 or iPhone 17, and they can take a long range shot, just testing their camera, and then it just captures you doing your private things in your own house. So the NDPA, the guidance specifically comes to say, hey, you have to, and that makes a lot of sense. Another thing that I like about the guide, just I mentioned it before, is how it regulates content creator. So yeah, you can say that, oh, I'm just doing my own thing. But the reality is that even though you are just shooting your content and it's for fun or satirical purposes, you still have to recognize the rights of the data subject. So I think that these are really good things. There is also the part of trying to kill 2 birds with a stone, or maybe 3, with the DCMI thing, that is data controllers and processors of major importance, and requiring that everybody should register, especially at the OETL level. So almost everybody is required to register, barring a few exemptions that are provided in the schedule to the guide. But what you find is that now everybody, while licensed DPCO, you find that everybody is now aware and is asking, oh, this privacy thing, what is it even about? And in trying to register, you can then sensitize them about some of the things that they need to bear in mind. So in terms of how this could cascade across the different things, I think it makes sense. Now, to the second leg of your question, whether this is now primed to be the regulatory framework for emerging tech like AI and blockchain, right? Specifically, as you mentioned. Again, I think that we can adapt it. Of course, there are still so many things that are not anticipated, that almost nobody actually anticipated, So it's an evolving market. But what I think is that by the time we begin to apply the principles in the NDPA and the guide, so these emerging technologies will be fine. For blockchain, it's a little bit nuanced, particularly if you're looking at it from like maybe the payment sector, so like cryptocurrency. It's a bit nuanced because blockchain itself promises you anonymity, right? Even though today we are realizing that anonymity is not total anonymity, right? So it's some form of anonymity that can still be broken midway, right? And so what happens is that because the technology itself promises you anonymity, the almost every time that anonymity is going to be broken, which again is a privacy right here in a sense, every time that's going to be broken, there has to be some form of legal basis for it. In the case of, oh, we are doing KYC, we are trying to monitor travel rule, or there's an investigation by a regulatory agency to determine whether there's fraud or all of those things, in which case they will need to unmask, or what we call in law lifting the veil. They will need to lift the veil of that transaction to figure out where that address is really coming from. And they trace all the hash until they get to the originating address. And then because by the time you were signing up on the exchange or on the wallet, you already are giving them information about you. So they can trace that and what a lot of people don't also know, I've heard people say this, people think that the wallet address changes per time. No, it doesn't. Your wallet address is your wallet address. So which is why some platforms can actually whitelist it. What that means is that they can save it like your phone number. So because that wallet address is tied to your KYC information. So if you mess up and they trace and figure out that the originating wallet address is your wallet address, they can use that to identify the information about you. And then you now begin to ask the question, whether this is a breach of your privacy right? But then you remember that one of the basis for processing data, which is also like an exemption to your right to privacy, is actually for in the interest of the public interest. So in that case, or public interest or legal obligation. So in that case, the cryptocurrency company, the blockchain company can come and say, hey, we're relying on this to be able to do this. And can you really say that is a violation of your privacy right? I don't really think so. In the context of artificial intelligence, so okay, just to wrap that up. So of course, what needs to be done is to now look at the loopholes to ensure that there are guardrails for when that unmasking is being done, and is ensure that it's being done in a way that it doesn't infringe on the fundamental right to privacy of the person. Now, on AI is a totally different. Whilst blockchain was built on the promise of anonymity and ensuring your privacy, AI was actually built on the breach of your privacy. So it's a totally different. AI actually intends to, because the way AI grows, like again, like every technology of like the Web 2, right? The Web 2 was a lot of data. Web 3 AI is infinite data. So what AI is, the way you want your AI to work, if you want it to work well, you have to feed it a lot of data so that it can be fine-tuned on that data. Now, the reality is that if there's a lot of data, there's a preponderance of data that is being used in a system, then there's risk. Remember that the GDPR, the NDPA, the guide, once there is huge chunk of data, it triggers something called the DPIA, the Data Privacy Impact Assessment. Now, because almost every AI, right, needs that significant level of data to be able to function, the reality is that the requirements for AI is going to be a little bit, not a little bit, a lot different from how you look at blockchain. Because the fundamental premise for AI is that I'm actually testing the limits of your privacy right to see how I can steal some data so that I can enhance my model, right? So again, there are already regulations here and there. For example, a key part of the obligations that the privacy laws, and I'm going to wrap up. Sorry, I know I'm saying a lot of things. The key part of the regulation that regulators have already provided for, that all controllers and processors, all AI companies will need to abide by, is sensitization. So that thing that I mentioned about you turning off the switch that says that the AI companies should not train their model on your data. It's actually supposed to be a key part of privacy notice, because the rule of transparency is that if you are going to collect any data from me, it has to be clearly, concisely, and expressly requested in a way that I understand, and in a place that I can have that information to be able to make an informed judgment. And the reality is that if you do not even know, because the thing is hidden somewhere, can you really say that you met the requirement of transparency? So we see that whilst that requirement of transparency was not expressly made for AI, it can still be applied in the case of AI. So I would wrap it up and say that whilst, of course, as the technology evolves, we would find new risk level, new risk profiles that will be unmasked or that will be coming up. The reality is, I think that what we have at the moment should be able to be adapted for the risks as we have them. Just that at some point it begins to become a stretch. But for now, I think that we are in a good place. Thank you.